Hello friends, Mandar here. I'm back with another video. Today we'll talk about a couple of rule-making changes that USCIS has announced. Some have to do with the H1B lottery for FY 2025, which starts in April. Others have to do with EAD AP and also fee increases. I'll also talk about the impact of these on the H1B and upcoming green card situation in the US. We'll talk about some of the situations where you can request USCIS to expedite your petition and also what to do if your date has become current. So a lot of important topics, guys. Watch this video until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration and lifestyle related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your specific immigration needs, before you take any action, you should hire a competent immigration lawyer. Check out the links in the description because those are affiliate links and you might find something interesting. And that will also help the channel. And while you are down there, do hit the like button. Let me know if you are going to watch the Super Bowl this year, which is the team that you are supporting. Unfortunately, the Patriots did not have a good season again, so I will not be watching most probably. Also leave your comments in the comment section below because I do read them and I respond to them as well. That's where I get ideas for my next videos. And if you want to get in touch with me, do contact me with my Calendly where you can book 30 minutes call with me or hit me up on the Patreon. Finally, I purchased my new domain and new email address, which is also listed in the YouTube section. So with that, let's start with our first topic of the day. Now let's first cover the fee increases because those have been significant. Here USCIS has issued final rule to adjust certain immigration and naturalization fees. This came in on 30th of January. The USCIS has final rule to adjust certain immigration and naturalization benefit request fees for the first time since 2016. But I will tell you there are some significant fee increases in this and you'll be shocked to see how much they have increased. Now what they are attributing this to is, and they are saying that final rule lowers the agency's required annual cost recovery by 727 million in part by considering the budget effects of improved efficiency metrics. It expands fee exemptions for special immigrants such as juveniles, victims of human trafficking, crime and domestic violence, military service and our Afghan allies. It provides special fee discounts for non-profit organizations and small business employees, allows half-price EAD applications for applicants for adjustment of status and reduced fee for adjustment of status applicants under the age of 14 in certain situations. Expands eligibility for 50% reduction for naturalization applications available to individuals who can demonstrate household income between 150 or 400% of federal poverty guidelines. So they are subsidizing some of the fees for the really underprivileged citizens with this fee increase. Implements a standard $50 discount for online filers, but that's nothing compared to what the fee increases are. Now let's quickly take a look at actual fee increases here. Now I-90 application to replace permanent resident card, the current fee is $455, the final fees is $415. So if you are replacing your green card, the actual fees has come down. But let's compare this to I-129 H1 classification, okay, for some small employer. So the current fee is $460 and the new fees is $780. That is $320 of increase in the fee just for that I-129 form for H1. Now what else can we look at? Now L1 fees, look at this, $460, that is the current fee, and then the new fee is going to be $925, which is 200% increase. For O1 visa, the current fee is $460. This is, by the way, the USCIS fee that I'm talking about. Lawyer fees are different, but for O1, it has increased from $460 to $1,055. That is about 129% increase. Let's keep going to see if there is any other thing that you can see. Lot of subsidized fees for family-based section, mind you. You can see it here. Now here is $485 adjustment of status fee increase $1,140 is the current fee, and then the new fee is $1,440. It's a $300 increase, and this is per applicant, mind you. Now here is something you can see. 526, this is for EB5 petition, immigrant petition by standalone regional center. Current fee is $3,675 per applicant. Imagine what this has increased to. This has increased to $11,160. That is 200% increase for EB5 526 application. So those of you rich people who are applying through EB5 category, you'll have to dip into your pockets even deeper to pay these filing fees to USCIS. That is 200% increase. Now let's see some other significant increases. If there are 751, removal of condition petition has increased by 26% from $595 to $750. Application for employment authorization filing papers increased from $410 to $520, 27% increase. Now 829, I wanted to look at this one as well. So EB5, you guys are really, it increased from $3,750, which is the fee for per applicant for 829, which is removal of conditions, to $9,525, which is 154% increase. A lot of fees have come down, mind you, for family-based sections. As you can see here, 100%. This petition for qualifying family member of U1 non-immigrant has gone to zero from $230. So they are subsidizing a lot of other fees for family-based section and people who are low income in non-employment based categories. So in summary, they have increased fees for a lot of employment based immigration sections and visas and non-immigrant visas. This fee they are saying is to subsidize other fee categories and also to help asylum seekers and such. It would have been a wishful thinking to say that would decrease the processing time for applications such as EAD, AP or green card, but that's not the case. This fees is going straight to anything but employment based section or visa, non-immigrant visa. Leave your comments in the comment section below. I would like to hear what you have to say about this fee increase. Okay, now let's talk about our next topic, which is USCIS announces strengthen integrity measures for H1B program. This also came out on 30th of January 2024. So USCIS has today announced a final rule to strengthen the integrity of reduce the potential of fraud in H1B process, including reducing the potential for gaming the system to ensure each beneficiary would have the same chance of being selected through the lottery regardless of number of registrations submitted on their behalf. USCIS is also announcing the initial registration period for fiscal year 2025 H1B cap and launched an online filing option for Form I-129 and I-207, which is for premium processing for H1B petitioners. Now really what it says is the final rule contains provisions that will create beneficiary-centric selection process. So they will focus on the candidate instead of their petitioners. Because remember what used to happen in the past. People have in the last couple of years have been taking advantage of this system and entering or registering their name in the lottery several times to several different employers. It was an unfair situation because people who applied more and more petitions or registration applications, their chance of getting through the lottery became much more higher than the regular legitimate candidates. So now USCIS is what they are doing is they are going to attach your selection process to your passport and travel document submitted. They're going to be beneficiary centric selection process. So under the beneficiary centric process, registrations will be selected by unique beneficiary rather than by the registration. This new process is designed to reduce the potential for fraud and ensure each beneficiary would have the same chance of being selected regardless of the number of registrations submitted on their behalf by the employers. Starting with FY25 initial registration period, USCIS will require registrants to provide valid passport information and travel document for each beneficiary. The passport and travel document provided must be the one of the beneficiary or if when abroad intends to use to enter the US while traveling, if they are given the H1B visa. So each beneficiary is only registered under the passport information and the travel document information. So that's what is going to be their key identifier and not the petitions that are filed by different employers. So this is a significant shift in the way USCIS is going to issue H1Bs or select H1B candidates. Now, additionally, they are also saying that H1B final rule codifies USCIS's ability to deny or revoke H1B petitions where underlying registration contained a false attestation or otherwise was invalid. So if you try to falsify your documents giving somebody else's, if some employer just steals your passport information to file for a petition or register for a petition, that is going to be a fraud. Now this registration final rule makes some provisions proposed in the October 2023 Notice of Proposed Rulemaking, and I'll leave the link in the description for you to read it in detail. The initial registration period of FY25 H1B cap will open at noon Eastern time on March 6th of 2024 and run through noon Eastern time of March 22nd, 2024. So it's coming pretty soon. It's next month. During this period, the prospective petitioners and their representatives must use USCIS online account to register each beneficiary electronically for the selection process with associated fees. Now here is another thing that I had mentioned in my last video, that they are creating organizational accounts and online filing form for I-129. What it means is they will launch these organizational accounts that will allow multiple people within the organization and their legal representative to collaborate on and prepare a petition for H1B beneficiary. So it won't be like you reach out to your employer and they will just go on their own and file a petition for you. There will be an organizational account which will serve not just the petitioner but also a legal representation and few other members who will collectively make a decision on your behalf to apply for your petition. It is much more coordinated way, making sure that there is a legitimate job offer for you. There is also going to be a paper filing process available, but they are encouraging online filing. There is also a fee increase attached to this again. So that's in a nutshell. So hopefully this will significantly reduce the fraud that has been going on in the H1B lottery selection in the last couple of years. Let me know what you think about this new H1B lottery program. If it's going to help, I truly believe that there will be less and less fraudulent applications in this new process. Now there is also some more things to come. Definition of specialty occupation. What exactly does it mean? How will they determine specialty occupation? How will they prioritize AI, ML, those sort of things? Difference policy. USCIS has traditionally given difference to prior H1B approvals, is expected to codify this policy if the Congress allows it to do so. Bona fide H1B employment. It will be codified in the law if Congress approves. Now this rule making is going to be a law. So all of these points are going to be by statute codified into the law. F1B cap gap protection. That is also critical because USCIS is expected to provide longer cap gap protection for F1 students who are beneficiaries of timely filed H1Bs that request a change of status. This is significant for students who are still studying and trying for H1B. So I know for sure that some of you are interested in stock trading, day trading, buying cryptocurrencies. I want to present you Webull. Webull is a trading platform. It allows you to buy stock, it allows you to buy options, do options trading, and also it allows you to buy cryptocurrency. Feel free to take advantage of this, join through my link and you will get those free stocks. Now there is one more rule making that I wanted to cover, and it is in this one which says improving the regulations governing the adjustment of status to lawful permanent residence and related immigration benefits. So what it says is the DHS proposes to amend its regulation governing adjustment of status to lawful permanent residence. The proposed changes include permitting concurrent filing of visa petitions and the application for adjustment of status for employment's fourth preference category, certain special categories, including religious worker categories, permitting the transfer of underlying basis of a pending adjustment of status, amending the definition of related to ineligibilities, clarifying when the visa becomes available for the purpose of age calculation, which is CSPA by the way, and authorizing compelling circumstances EAD for certain derivative applicants waiting for an immigrant visa. The intent of these proposed changes is to reduce processing time, improve the quality of inventory data provided to the partner agencies, reduce potential for visa retrogression, and promote efficient use of immediately available visa petitions. I think this is a positive news. The way I read it is, it's more friendly towards the family-based section than the employment based section, but if their language remains neutral, it will apply to both family based and employment based. Let's see what comes out of this rule making. They will be publishing it very soon. I'll be ready to cover it. So if you haven't subscribed to my channel and hit that bell notification, as soon as this proposed rule changing comes into play, I'll be sure to make a detailed video out of it. Now there is one thing that I'm noticing from a lot of calls that I'm doing over the weekends, and that is the extensions of H1B and H4 dependents. Now in some cases the H4 dependents are the application that is being done in the US 539. It's taking a very long time, over a year. In fact, in some cases the H1B's extensions is approved, but the dependents H4 is not approved. Now there are a couple of things that you can do. You can request the case status update to expedite, because if the H1 has come in, the H4 should also be approved. Additionally, what you can do is if you are planning to travel outside of the United States, the H4 dependents can travel back, say to Canada by land border and get their H4 reinstated or extended. If you are traveling to India or any other country, their H4 can also get renewed at the consulates along with their H1B stamping. So you don't need to have your approval within the US. They can just go to India and along with H1B stamping, they can also apply for H4 stamping. So that is also possible. So I just wanted to cover this point because few people have mentioned me that their H4s are taking way too long. Now if your priority date has become current and if you still haven't received your green card, there are a couple of ways to expedite or actually trigger USCIS to look at your case and approve your 485 application. I have made numerous videos in my past to cover this topic, but if you want to talk to me about your particular situation, do contact me on my Calendly. The link is in the description, or you can ask me questions on my Patreon as well. There are certain strategies that you can use that have really helped people to get their green cards if their priority date has been current for a while. That's all really I wanted to cover in this video. If you like the content of this video, do hit the like button and consider subscribing to my channel. Remember, I still have my giveaway going on that I will be announcing towards the end of February. And I'll see you in the next one.